My speech will have to do with the International Seabed Authority. We will have a look. I'll try to briefly show you or give you an overview of what has led us to the current situation of the International Seabed and Ocean Authority, how the oceanic seabeds are being managed, the advances, the progress we've made until now, despite the lack of support, to say it somehow, of the international community towards the authority, and also the challenges that the authority is facing towards the future for the next few years in a more or less immediate future. Then I will conclude with some final reflections, some final general ideas to summarize what I say. I have to undoubtedly start by referring to the common place that the declaration by the visionary delegation of Malta meant, headed by the ambassador Nick Bader, very frequently mentioned during the past few months in any kind of commemorative event related to the 30th anniversary of the UN Convention on the Law of the Sea, produced in 1982. So, briefly, this is what it is. This is the starting point, not only for everything that has to do with the seabed, but with its proposal in the General Assembly, where it was said that the seabed beyond national jurisdiction should not be subject to appropriation by any state and should be used only for peaceful purposes and for the benefit of the whole human beings. Well, with this statement, there's a tension after this statement, and this led to the General Assembly, although it showed some reject at the beginning. It finally led the General Assembly to create a specific commission to work on this issue before all the negotiations within the framework of the third conference were opened. Resolution 2749, published some years after, was also approved in an annex, a declaration of principles whose aim is to talk about how to manage the seabed and oceans below or beyond national jurisdiction, and it proclaims that before the initiation of any negotiations, this seabed and its resources should be the common heritage of all mankind. The International Authority of Seabeds and Oceans actually arises from the preparatory work of the third conference, but it crystallizes and becomes a reality in the convention, in Part 11 of the UN Convention on the Law of the Sea, as you all know, Annexes 3 and 4. And it is there where the exploitation and exploration of resources regimen is articulated, of what is called the area. There's also a mention to creating a specific authority or entity for the management of this marine area, which has to do with all the ocean and marine seabeds outside national jurisdiction, and in regard to mineral, solid, liquid, and gas resources, including polymetallic nodules. When the negotiations for the third conference started, two groups of states were formed with regard to this question, as you all know. We had, on the one hand, or even within these two groups of states, there were some differences, internal differences, but well, to speak broadly, we had industrialized countries and developing countries. Industrialized countries wanted to create an international organization limited to the coordination and generation of particular licenses and permits for states as well to handle and manage the seabeds, and the other group of countries, developing countries, who thought that the authority should be the only one to directly exploit those resources, and the benefit obtained should also be managed by them and targeted at developing countries. At the same time, the idea was that with the benefit obtained from this extraction of resources, the price of the resources obtained inland would not decrease extraordinarily, particularly in developing countries. The balance that was seen in the content of the Convention's articles had to do with a consensus more or less reached in the 80s, but which was later on broken basically by the United States, who voted against the Convention, as we were told yesterday in clear detail by Professor Pastor DIRCO, together with Turkey, Israel and Venezuela. These are the four countries who still have not ratified the Convention. The United States has announced that Obama has announced repeatedly he had committed himself to doing so before the end of 2012, at least in the last meetings that have the opportunity to attend. But the fact is that this has not happened yet. No ratification has been issued yet. This abstention of the United States led to the abstention of other states as well, as we all know perfectly well, Spain, Germany, and many other countries which currently belong to the European Union, as you probably know. For a decade, more or less, the Preparatory Commission, both from the Authority and the International Authority for the Law of the Sea, worked in a sort of pessimistic way, particularly with regards to the Authority, because many of these industrialized states ended up even adopting internal legislations which authorize their operators to exercise exploration and exploitation activities on these seabeds beyond the national jurisdictional waters. The United States, Germany, France did so. But as we all know as well, when the deposit by Guyana of instrument number 60, this made irreversible for industrial states to make the Convention be enforced on the 16th of November 1994, and it led to this accelerated process of negotiation, which, well, thanks to the good auspices of the, by that time, Secretary General of the United Nations, but also thanks to the fact that, on the one hand, industrialized countries were not so reticent and or so hesitant in terms of, well, opening up their hands to the Authority and to the United States, because the technology needed to extract these minerals had become very expensive during that period, etc. And also the price of these minerals had decreased extraordinarily. So all these circumstances basically led to the fact that an agreement was reached in July 1994. The agreement on Part 11, theoretically on the interpretation of Part 11 of the Convention, but as we all know, in practice, an agreement on the amendment of Part 11 of the Convention, which comes to amend, obviously into quotation marks, the Convention. Obviously, it is still an agreement on the interpretation and application of the Convention, theoretically, but in practice, as I'm saying, it substantially modifies the content, the spirit of the provisions of that Convention. It introduces the interests of industrialized countries, so it is a kind of amendment. It somehow de-virtualizes some of the most ambitious schemes that developing countries had managed to introduce in the Convention. So, well, obviously, the company has been enormously disadvantaged, and the capacity of states to act on their own has been also affected, is a fact, after that agreement in 1994. The states do not have to support the company anymore. There's no obligation to transfer technology. Many of the privileges that developing countries had derived from exploitation in an area, etc., etc., the original market rules which were meant to protect developing countries, etc., etc. Also, the Council of the Authority has also been reinforced. The restricted organ of the Authority has been reinforced in opposition or versus the Assembly of the Authority. And well, With this scenario, well, what has the International Authority, the International Seabed Authority managed to achieve up till now? Well, the authority sort of survives with quite a scarce budget based on the quotas paid by the states, which are proportional to the quotas they must pay the United Nations. For example, the European Union paid in 2012 $163,050 US. Many states are failing and are not paying the due quotas. They have some problems with their budget. There's also a budget which includes voluntary contributions, and many states are not contributing to this. The European Union, due to an internal decision and also a transparency problem, cannot contribute to this voluntary fund because it is destined to facilitate the participation of developing countries, but there's no resource traceability in terms of the destination of those resources, so the EU is limited in terms of how it can contribute to that fund. Despite of this, the authority keeps on operating and working quite adequately. It's made progress in terms of the definition of the states and operators in relation to the operations in the area. It started to adopt what's called the mining code, which establishes some duties and rights of the parties in relation to the exploration, at least for the moment, only the exploration and survey of resources in the area. It is a big set of rules, procedures and regulations, which, as I've said, until now, have only been regulated, or until now we've only managed to regulate the exploration and prospection of polymetallic nodules, sulfurs and ferromanganeses coasts with a high cobalt content. It's quite a lot because up till now these are the activities which are actually being carried out in the area. Up till now, only exploration and prospection or survey activities are being carried out in this area, so they are being carried out within a stable legal framework. Also, something that we must highlight, although I don't want to enter into many details here because I think that there are at least 2 communications which will tackle this issue, but this comes together or is issued by the, well, it has a lot to do with the rights of the states parties, which promote operators carrying out activities in the area. And there's been a statement issued by the tribunal regarding these issues, which has clarified the obligations of the states per se, obligations and duties related to the operations carried out by their operators in terms of live diligence, but also direct state obligations in terms of helping the authority, implementing the precautionary principle, adopting measures to protect the environment, offering a response to the authority in the case of an emergency. Also, the scope of direct responsibility by a state, a party which promotes the operators carrying out activities in the area. This has also been classified because a non-compliance by an operator of the current legislation doesn't directly create the responsibility or lead to a responsibility by the state promoting that operator. He also must incur into a non-compliance of its obligations and cause a damage. That non-compliance must cause a damage, and this is independent from any other responsibility due to international common law or responsibility due to an illicit fact that a state must have. There's no solidarity with operators, etc., etc. The state promoting activities must also adopt all the necessary measures within its internal legal framework. Work is being done in this field. The states that are carrying out activities in the area, at least some of them, have sent the mode models of the internal regulations they adopt to the authority, so that the authority can try to help other states that want to authorize their operators to carry out activities in the area. Well, it can help them facilitate this normative or regulatory process of internally creating their own legislation, and it can help the authority create a sort of protocol or scheme that the different states can follow when developing these activities. Also, we've seen the development of explorations. There are currently 17 contracts in force with different companies, some of them only linked to a state, some others linked to several states, and they are all obliged to present in annual reports. Also, they have to adopt binding measures in terms of environmental protection. And the final advance made that I would like to highlight is that within the field of environmental protection, we should stress the decision adopted by the last Assembly and the Council celebrated this year in 2012, last summer, in terms of an environmental planning plan in the Clipperton area, which is where a good part of these activities are being carried out, of these explorations are being carried out, in compliance with the obligation that arises from the Convention itself, in terms of guaranteeing that any activity carried out in an area doesn't have a harmful effect on the marine environment and on the ecosystem in general. This regional organizational plan, a cooperative plan as well, has been adopted. It will be reviewed in 3-5 years, and what it does is, at the moment, it paralyzes the possibility of granting any new authorization for the exploration activities carried out in this area. What are the challenges ahead of us? What are the challenges that the authority is facing? Well, first of all, the company. The company has not been born, to say it somehow. And looking at the spirit of the negotiations being carried out, looking at the political burden placed on the states for this to arise, well, the works carried out by the authority are still at a very preliminary stage in terms of allowing the company to work on its own. Secondly, and as I've said before, regulations have been adopted in relation to exploration and survey, but we've still not managed to adopt a regulation, rules, standards and procedures related to exploitation itself. And the first exploitation contracts will end in 2016, which means that the first companies which will be in a position to exploit resources could do so from that date. But in order to do so, we need a legal framework which regulates these activities previously. The Technical and Legal Commission, in the meeting held during the last assembly of the authority, they've been asked to urgently start to work in this field, and the idea is that in July next year we will be able to advance in terms of the content of this code of exploitation, how regulations, kind of machinery and equipment, the consequences it can have, the percentage of benefit that must be posed on the commercial exploitation and usage, and that must be transferred to the authority so that the authority transfers it as well to developing countries, etc., etc. And finally, the last challenge, well, I don't know whether it is at the same level as the previous one, but it is another challenge indeed, and a very important one indeed, which is alive. I'm not going to spend a lot of time on this because probably Professor Franz will tell us more about this in more detail. But as you all know, a new negotiation process is opened. Well, there's been a call. I don't know whether opening is a very optimistic word, but in the Rio +20 conference, The states were invited to sit down and start negotiating a new implementation agreement for the convention, the third implementation agreement, in this case related to biodiversity protection beyond national jurisdictional waters. And with regard to this question, several workshops will be organized throughout this year. The idea is that negotiations will end in 2014, and well, undoubtedly, this is very much linked to the authority and to the work of the authority. It's clear that the authority per se only has power to control mineral resources, not any other kind of resource, which is the implementation field of the possible implementation agreement which could be reached in terms of biodiversity. This is clear, but it is also true that there are some states which state or support the possibility that instead of asking a new international organization to carry out the task of managing, of creating marine protected areas, of managing access to these areas and sharing the benefits obtained therein, etc., etc. Well, the whole process involved in patent control on genetic resources, etc., etc., in waters beyond the jurisdictional level. Well, the authority could, instead of this, could have this power. The authority could have the power to do this instead of creating a new international organization. It is very early to talk about this yet. There are very different positions, by the way, with regard to this. On the one hand, we have a group of states which do not want the authority. They are not satisfied with the work being done by the authority, so they don't want it to get involved into these new biodiversity activities carried out outside jurisdictional waters. And there are also some other states which are even trying to stop the implementation, the approval of an implementation agreement. There's even a group of states which is trying to stop this. Also within the European Union, there's no clear position or common position with regard to this topic. So, my final reflections, my final remarks. What can we say with regard to the ocean seabeds and the authority? Well, we are going through a consolidated institutionalization process. There's no doubt about this. This is the single area which is common heritage, which has an authority managing this, and this marks a difference when compared to the terrestrial area. Despite the lack of support by many states, the authority has managed to make progress in terms of regulation, etc. And, well, we now have to see to which extent we can define an exploitation regulatory framework which would be linked to the real economic feasibility of activities carried out in the area. Again, we are facing the fact that there's a deficit for 2014 of the mineral products obtained only from the seabed, not from any other part of the planet. There's a deficit, a lack of these resources, but at the same time it's very expensive to obtain them. So we have to see to what extent the authority is really able to respond to this challenge. We will also see the clarification, on the one hand, in regard to this field, and on the other hand, in regard to biodiversity. We will also see, as I'm saying, the clarification of its role in the next few years. Thank you very much for your attention. Liquid and gas resources, including polymetallic nodules. When the negotiations for the third conference started, two groups of states were formed with regard to this question, as you all know. We had on the one hand, or even within these two groups of states, there were some differences, internal differences, but well, to speak broadly, we had industrialized countries and developing countries. Industrialized countries wanted to create an international organization information limited to the coordination and generation of particular licenses and permits for states as well to handle and manage the seabeds, and the other group of countries, developing countries, who thought that the authority should be the only one to directly exploit those. My speech will have to do with the International Seabed Authority. We will have a look. I'll try to briefly show you or give you an overview of what has led us to the current situation of the International Seabed and Ocean Authority, how the oceanic seabeds are being managed, the advances, the progress we've made until now, despite the lack of support, to say it somehow, of the international community towards the authority, and also the challenges that the authority is facing towards the future for the next few years, in a more or less immediate future. Then I will conclude with some final reflections, some final general ideas to summarize what I say. I have to undoubtedly start by referring to the common place that the declaration by the visionary delegation of Malta meant, headed by the ambassador Nick Bader, very frequently mentioned during the past few months in any kind of commemorative event related to the 30th anniversary of the UN Convention on the Law of the Sea, produced in 1982. So, briefly, this is what it is. This is the starting point, not only for everything that has to do with the seabed, but with its proposal in the General Assembly, where it was said that the seabed beyond national jurisdiction should not be subject to appropriation by any state and should be used only for peaceful purposes and for the benefit of the whole human beings. Well, with this statement, there's a tension after this statement, and this led to the General Assembly, although it showed some reject at the beginning. It finally led the General Assembly to create a specific commission to work on this issue before all the negotiations within the framework of the third conference were opened. Resolution 2749, published in some years after, was also approved in an annex, a declaration of principles whose aim is to talk about how to manage the seabed and oceans below or beyond national jurisdiction, and it proclaims that before the initiation of any negotiations, this seabed and its resources should be the common heritage of all mankind. The International Authority of Seabeds and Oceans actually arises from the preparatory work of the third conference, but it crystallizes and becomes a reality in the convention, in part 11 of the UN Convention on the Law of the Sea, as you all know, annexes 3 and 4, and it is there where the exploitation and exploration of resources regimen is articulated, of what is called the area. There's also a mention to creating a specific authority or entity for the management of this marine area, which has to do with all the ocean and marine seabeds outside national jurisdiction, and in regard to mineral, solid,